Good afternoon and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tulo Hoyane. This afternoon and evening, I would like to take you through what happened in court today regarding this application that Advocate Mnisi has now made, which I maintain up to this very moment that it should never have been made, that it was a misdirection on his part. It was also a misdirection on the part of the court to accede to such an application. And it was also a misdirection on the part of the prosecution to even purport to oppose that application. When he began his address, let us start with Mnisi. When he began his address, Advocate Mnisi referred to Section 35.3 of the Constitution of South Africa. Section 35.3 of the Constitution of South Africa, in simple terms, gives the right to every accused person to be given adequate facility to present his defense and be afforded adequate facilities to do so. That is what Section 35.3 of the Constitution is all about. Now, these are fundamental rights. This is a fundamental right. Now, I want to focus on the issue of a right conferred by the Constitution. Rights conferred by the Constitution come in all shapes and sizes. But they are fundamental rights, like, for instance, the right to life. The right to life is conferred by the Constitution, and nobody can take away your life under South African law because the Constitution forbids it. Now, rights are something, the Constitution, let me start with the Constitution. The Constitution has been passed by a parliament, which is the body responsible for making the laws of this country. Now, Parliament, in its wisdom, has conferred Section 35.3 rights on every accused person. In other words, those rights, right, accrue from the Constitution. It is not a question of you having to go anywhere or you going before any court, to claim these rights. Let me put it that way. You see, you can't go to court and claim your right to life. Your right to life, was conferred on you at the time that the South African Constitution was passed, way back in 1996. This is the 29th year now. So this Section 35.3 rights that Mnisi is referring to in that application were conferred by the Constitution at that time. Now, even before the accused committed the crimes with which they are charged, they had those rights under the Constitution. After their arrest and subsequent trial, they still had those rights. In other words, they don't have to go before any court to claim those rights because the Constitution has conferred those rights on them some 29 years ago. This is why I'm saying, under the circumstances, you see, Advocate Mnisi has to cross-examine Moses Mabasa, Warrant Officer Moses Mabasa, about that evidence relating to whether or not Mncube, the third accused, had a gold tooth. That is where all this comes out of. Now he realizes that it might be because he's been ambushed with this evidence. Right? Remember, this is not evidence. Mabasa's evidence was not disclosed to the defense at the beginning of the trial. And this is the prejudice that Mnisi has been talking about. Now, when he has to cross-examine Mncube, what occurs to him is he will need to lead evidence to counter the evidence put before the court by the prosecution out of a photo of accused number 3, in which photo accused number 3 is seen smiling, and in which photo a gold tooth was identified in Mncube's mouth. Now, you must also know that an accused person is presumed innocent until he's proven guilty. He does not have to go to court to prove his innocence because he is already presumed innocent. And it is the prosecution that bears the burden of proving that guilt. Now, under the circumstances, following this ambush by way of this witness, what Mnisi had to do was to simply put it to Warrant Officer Mabasa that, in simple terms, that the evidence that you are tendering before this court is false. Put it to him that way, in those blunt terms. And at a later stage, Mncube will come before this court and testify to the effect that he never had a gold tooth. He will also adduce expert evidence by a dental surgeon to disprove or to indicate that he never had a gold tooth. At that stage, the defense would then apply, and this is the interesting part, would then apply, right? Because this will be the defense case now. Mabasa will have been out of the box. The defense would then have to reapply for the recalling of Mabasa to confront him with that expert evidence by the dental surgeon to say that Mncube never had a gold tooth. That would be a very interesting scenario because we are seeing the prosecution make applications, to recall witnesses or to lead evidence that they ought to have led long ago in chief. And then see how that application pans out. But you see, the crucial thing here is Advocate Mnisi did not have to go before the judge to make an application or to ask, in effect, asking for permission from the court to say, can we please, in simple language, can we please be allowed, in view of this new evidence, can we please be allowed to lead evidence of a dental surgeon who will dispute that Mncube ever had a gold tooth? He's asking. You see, my issue is on, or my emphasis is on the making of an application under those circumstances. The right is already there. Mncube has already got that right to a fair trial and to adequately prepare for his defense and so on. You don't have to go to court to claim that right or to ask that the court must give him that right. You see, this is a process above the court itself. He has already got a right conferred on him by the Constitution. Now, it is as if Mncube does not have that right, or it is doubtful whether he has got that right, such that he now goes before the court and says, I would like to do the following. I would like to call a dental surgeon who is an expert in the field. Can the court please give me permission to do that? When the Constitution clearly says he has got that right, and that right he has always had since 1996. It is not a right, for that matter, that the court can give to him or even to take away. It cannot give him that right. That right is given to him by the Constitution and by the Parliament of South Africa. It cannot be taken away by the court because the court cannot make a ruling that says, no, you don't have that right, and go against the Constitution. Do you get my point? My point is, Mnisi should never have burdened himself with this application. Because Mncube already had that right. Why ask for something which you have already got, which the Constitution has already given to you? Interesting, isn't it? But you know, as legal practitioners, we all see things in different ways. Mnisi has got a certain approach to this, and I respect him for that. You see, I don't have to agree with everybody. Neither does everybody have to agree with me. But this is my point of view, that it would have been much easier to say, because we already have this right, all we need to do is to assert it. Tell the court that we want to assert that right, not to go before the court and say, can you give us permission to assert this right? The court has got, the court does not feature in that sort of scenario. So having said that, in a sense, I think, and I've always maintained that this application is misdirected. But let us see where it goes. Because you see, Mnisi is putting up a spirited fight. He's doing the very best for the defense of his client. But having said that, I really don't think that you ought to ask for something that you already have. Having said that, let me thank you for watching this video, and please have a wonderful, wonderful afternoon and evening. Thank you very much.